Good morning. It's 10:45. We have a quorum. I call to order the meeting of the panel on Manpower. Welcome, everyone. The first agenda item is information paper issued since the last meeting. Since the last meeting, the Secretary has issued an information paper to members, the details of which are set out in the agenda. The second agenda item is items for discussion at the next meeting. The Secretariat has issued the list of outstanding items for discussion and the list of follow-up actions to members. The next regular meeting will be held at 10:45 on a Monday, 28th of April. We will discuss two items at the next meeting. One, the updated talent list. Two, retention of 3 time-limited directorate non-civil service posts or supernumerary civil service posts in the Labor and Welfare Bureau. If members have no objections, these are the items we'll discuss at the next meeting. Moving on to the third agenda item, retention of 1 time-limited supernumerary post of Chief Labor Officer in the Labor Department. I will now invite representatives of the administration to come inside the conference room. This is a staffing proposal. All other electrical members are invited to take part in the discussion of this item. We have in attendance today Mr. Chris Sun, Secretary for Labor and Welfare, Mr. Raymond Ho, Deputy Commissioner for Labor Administration, Mr. Raymond Liang, Assistant Commissioner for Labor Relations, and Ms. Christine Budd, Registrar of Trade Unions of the Labor Department. Members who wish to speak, please press the Request to Speak button. I will now ask the Secretary to brief members on the paper. Thank you. Chair. Good morning, members. The proposal is to retain a time-limited supernumerary post of Chief Labor Officer CLOD1 in the Labor Department for a period of 3 years. We last proposed for the term to be 3 years, so we are again proposing the term for this occasion to be 3 years. And the post will lead the Registry of Trade Unions, RTU, and the Workplace Consultation Promotion Division, WCPD, to strengthen the regulation of trade unions to safeguard national security and promote workplace consultations to foster harmonious labor relations. The Chief Labor Officer will also be dealing with national security work. There are 4 areas: 1, to strengthen the regulatory regime, and 2, to discharge the implementation duties. 3rd, promote national security education, and 5, to safeguard national security in the Labor Department. We will soon make amendments to the Trade Unions Ordinance, but it will not end after the legislative amendments. This is a continuous effort. What I said earlier, the work is long-term and continuous. We propose to retain this post for 3 years to be prudent, to make sure we are allocating resources effectively, and we'll see if this post will be retained in future. This post's work would involve enforcement. It would also involve coordinating with different departments and stakeholders, with other labor unions. For example, we would need someone with experience and sensitivity to formulate the relevant policies to meet the challenges, including safeguarding national security. The officer must be experienced in liaising with trade unions, and The relevant officer will formulate relevant policies and measures to foster harmonious labor relations. Chairman, as you may know, right now, for the CLO posts, we only have 3 permanent posts. Out of all the departments, it's few. And the officers have quite a heavy workload, especially for this post. This post would be dealing with labor relations. The other one would be responsible for statutory minimum wage. The third one would be working on abolishing the MPF offsetting arrangement as well as the reimbursement of maternity pay leave scheme. There is really no way for other officers to take up the duties of this post. As this post has been counted towards establishment, it will not increase the number of establishment posts. I therefore call for members to support this proposal. Thank you, Chair. Thank you. I will assign a 4-minute time limit. I will read out the order in which members are going to speak. Professor Chen Wing-Kong, Mr. Kingsley Wong, Mr. Tang Fei, Mr. Chao Xiu-Chung, Mr. Li Chen-Kang, and myself. First, Professor Chen Wing-Kong. Thank you. Chair, I did not object to the proposal to ensure adequate directorate support to foster harmonious labor relations. But I would say for the proposed duties, it would be to administer the trade unions ordinance to safeguard national security. So will there be KPIs set while we are trying to promote workplace consultations? There should be enhancement of awareness of safeguarding national security and shouldering the responsibility of safeguarding national security. This post is because since the second half of 2019, there has been significant changes. This post was created. Apart from regulating trade unions to safeguard national security, this post will also promote workplace consultations to foster harmonious labor relations in accordance with Annex 2. We already have a chief labor officer working labor relations. Why is it that we need another proposed time-limited post to work on labor relations? What will be the division of work between the 2 chief labor officers? How can you prevent overlap of their work? Thank you. Secretary, thank you, Professor Chan, for your questions. On regulating trade unions, the priority is to complete the legislative amendment exercise of trade unions ordinance so that we have solid legal foundations to safeguard national security. The next stage is implementation. We have over 1,400 trade unions. Apart from the registry of trade unions, we, as Professor Chen Wing-Kwong said, the trade unions themselves are responsible for safeguarding national security. There is much to do in this regard apart from promotion. In the legislative framework, we need to do more. I think with large-scale unions, there is not much problem with that, but for the smaller-scale trade unions, they would need more help, and the chief labor officer can enhance support for them. As for the division of work between the 2 chief labor officers, I'll let the deputy commissioner elaborate on my answer, but the 2 posts are different. Even if the post is to be retained, we do want to better foster harmonious labor relations. For the other permanent post of Chief Labor Officer Labor Relations, they would deal with the more routine matters, the labor disputes, and the workload is very heavy. The officer has been working well and has practiced great leadership in resolving labor-related disputes early on. I'll let the Deputy Commissioner elaborate on my answers. Mr. Raymond Ho. Thank you. I have some supplementary information. We have right now a permanent chief labor officer, labor relations, to supervise the 10 divisional labor offices, and they would directly deal with labor disputes and claims. They would supervise the labor relations branch and provide mediation services, the labor administration branch. We would also make sure that there is effective regulation of labor management. So with the labor claims and disputes, we are providing effective mediation services. For the other chief labor officer, they would deal with education and prevention and promotion as well to foster harmonious labor relations. They would take a more prevention-oriented approach. We think that there is a need to enhance work in this regard. We do have some tripartite groups, and we can probably set up more of such groups to foster relations between the employers, the trade unions, and the government to promote communication in a specific sector. On a corporate level, there is room to enhance labor-related negotiations and the practice of good human resource management so that corporations can have these best practices for reference. Thank you, Mr. Kingsley Wong. I support the retention of this post. This post is very important because we are trying to amend the trade unions ordinance. This is a heavy workload. The post will also help with promotion of national security and national security education. We are talking about safeguarding national security, and we have had 2 seminars held. Apart from that, how can we actually enhance national security education for trade unions? In fact, the labor sector recently wanted to hold a seminar, but for trade unions, we have seen during the black-clad violence, many would abuse trade unions. So we need to tell trade unions what to do and what not to do to remind them so that they won't breach the law inadvertently. In fact, trade unions are not non-charitable organizations. They sometimes face restrictions and they face difficulties. Can you enhance support for trade unions to hold activities and provide necessary support, financial or otherwise, for them to hold activities to promote national security education? With the amendment of trade unions ordinance, the workload will be heavy, but I think the period of 3 years is too long. Wouldn't 2 years be enough? I think the work is going smoothly. I think within 1 or 2 years, the legislative amendment exercise should be complete. Next, on establishment and manpower deployment. We have talked about within a short period, there are many trade unions being established, or many who have applied for trade unions to be established, and therefore we needed an officer because the workload was heavy. With the legislative amendment exercise of the trade unions ordinance completed and with much less applications, I think we will not need an officer for there for that long. And with a proper mechanism, we wouldn't have to have that much manpower. With the lapse of this post, can we go back to having only 1 chief labor officer dealing with labor relations and the 2 other chief labor officers dealing with something else? We're faced with a tight fiscal position, so we should try to save money. the registry of trade unions should not have that much of a workload in future. And once you have a formula mechanism, the workload will be much lighter. Can you consider the suggestion? Thank you.
Secretary, thank you. First, I thank Mr. Wong for his suggestions. We can explore these ideas. We want to get trade unions to help out with publicity and education on national security, that is getting committed trade unions who wish to do this, so that we can do the work with greater cost effectiveness. But not every trade union has the capability. They need to know the work in national security. Larger trade unions with more resources at their disposal are something we can work with, and we can step up the work. Now, on extending this post, now we have kept the extension to 3 years, and that's the minimum. We have to think about whether there's a long-term need for this post after 3 years. There's never an end for national security work. After the legislative amendment, we will have a better legislative framework. With the framework, we will still need someone to administer the law. We need someone in charge. Now, after the Black Clad violence, there was a surge in applications for trade union registrations. But those actions were not meant to set up trade unions. There were other purposes. Now things are different, but that's not to say we have less work. After the amendment, there will be tighter regulation over ties with external organizations. There are compliant trade unions. In the past, little reporting was needed, but in the future, after the amendment, the reporting will be required, and that means a lot of work. And trade unions will have to report more details. In the past, things were simpler, but in the future, there will be more regulation. So we expect that for smaller trade unions, they will need greater assistance from the RTU. So it won't be very straightforward. So that means the registrar of trade unions can simply expect more and more work down the road. This post holder will also have the power for more inspections and enforcement, so more work will be down the road. Our goal is to step up the protection of national security. Now, we do have the formula for determining the statutory minimum wage, and it appears that there are fewer disputes at the meetings of the Minimum Wage Commission. In the past, we got an amendment to the law every 2 years, but now we get annual amendments instead. So we're getting twice the amount of legislative work, even though some work is taken away from the Minimum Wage Commission. So it's not apparent that the chief LO in charge of the minimum wage can take over the work. So let's first keep this post for another 3 years, and then 3 years from now, we review the situation about the way forward. Next, Mr. Tang Fei. I support keeping this post. This post holder will undertake a wide range of work: supervision, guidance, education, enforcement, everything. So you want to extend the post every 3 years instead of regularizing the post, making it part of the permanent establishment. So my question is, what key performance indicators would there be to measure the work of this post when you determine whether you want to keep the post for another 3 years? The work for this post holder will balloon. I'm looking at paragraph 5, item 1. As at the end of 2024, there was a 54% rise in the number of registered trade unions from 2019. So for the CLO and also the officers working under the CLO, my question is how many support officers are there be for the CLO? Secretary. Thank you. I agree with Mr. Tang. There was sizable growth in the workload for trade unions. There was a tsunami-like growth. It was a surge in applications. So we had to create this time-limited chief labor officer. Within the labor department, we also deployed officers internally. So we did not require extra resources. We simply asked other divisions to tighten their belt. We redeployed the resources internally to help out the registry of trade unions. As for the details, my colleague can tell us more in a moment. When the application levels fall, we would redeploy the officers for other work. We make the internal redeployment, but that does not involve any extra resources. We redeploy our resources internally. Now, on how we will decide whether we will still need the post 3 years from now. Now, there are some straightforward KPIs. Number of inspections, for example. How many sets of applications we have reviewed and how much publicity we have done. But on the long-term need for this post, we will have to look at national security and regulation of trade unions. We will still have to review the matter. The prudent approach is to look at how things work 3 years from now, because by then, the amendment will have gone through. We will have to look at the level of trade unions, and we will also get a clearer picture of the compliance of the trade unions with the amended law. How much follow-up work is required, whether things have stabilized. So the prudent way is to look at how things go 3 years from now, and then we make a decision. Mr. Tang Fei, anything to add? No? Mr. Chao Siu-chung. Thank you, Chairman. This time-limited post was created in 2022. Back then, the work was focused on amending the trade unions ordinance, and now the work is mostly done. The bill is about to be presented to LegCo. Even after the law is amended, this post will play a key role because new requirements will come with the amended law. The work will cover monitoring the ties between local trade unions and external bodies. So I put this question, say an external body changed its behavior, and then the RTU will have to keep an eye on the ties between our local trade unions and that external body. And when donations, subsidies from external bodies are involved, the RTU will be there to vet those applications. So we will need someone to keep an eye on all that work. So I support keeping this post for another 3 years, and then we will review whether there's a need for further extending the post. My question is, how will we regulate trade unions going forward? Back in 2022, there was a surge in the applications for trade union registrations. The Labor Department told us they had an establishment of roughly 20 people in charge of the work. And then they hired an extra 17 or 18 contract staff. So my question is, when the RTU implements the amended law, what will be the establishment be like? Will there be enough support for the RTU? This post holder will also be in charge of the Workplace Consultation Promotion Division. This is a new arrangement. So we're upgrading this division. We used to have just a senior labor officer in charge. Now we will put a chief labor officer in charge. Now, of course, this division will be important. One key task of this division over the past few years was guidelines on industry work hours. We have been campaigning for standard work hours for more than 10 years. We're getting nowhere. The long work hours in Hong Kong are seeing no change at all. So I hope the Workplace Consultation Promotion Division can do more on work hours in the future. We're upgrading the WCPD now, so I wonder if we have plans about stepping up the work on work hours. Secretary. Now I'll see if the Deputy Commissioner or the Assistant Commissioner can tell us more about how we support this time-limited CLO in functioning as the Registrar of Trade Unions. Indeed, when the workload rises sharply, we do hire temporary officers to help out. As Mr. Chao Siu-chung can see, as we extend the 3-year post, we're also proposing that this post holder will also take over work on the WCPD. But the primary focus for this office holder will be the Registry of Trade Unions, and that will take up most of this officer's energy. There will be just 4 chief labor officers. It will be hard to redeploy the work again. So we're simply asking these officers to take up a bit of work of the other CLOs. So that is not to say that we think this officer can take up much more work about the WCPD, because the focus will be on trade unions in the next 3 years. We're simply saying the other 3 CLOs are also heavily occupied. We're asking this office holder to help out. This post is no longer a senior labor officer. Instead, we have a chief labor officer. So this office holder will be in a better position to handle the work of the WCPD. That is not to say we have big plans for work hours. We simply want to do more in terms of tripartite consultations and achieve better results. Our tripartite model has worked well. So for this officer, once they have taken care of the trade unions, this officer can also help out with the tripartite consultations. That's my expectation. Now, maybe over to the Deputy Commissioner for a bit more details. Now, the establishment for the RTU. Mr. Raymond Ho. Mr. Chow is right. We have 20-odd officers at the RTU. After the trade union ordinance is amended, we will keep an eye on the workload. If needed, we'll try to redeploy officers within the Labor Department internally. We will be flexible to make sure the RTU can take forward its work effectively. Mr. Michael Lee. Thank you, Chairman. Some years ago, there were people with ulterior motives trying to engage in illegal activities under the guise of trade unions. That's still fresh in our memory. So that points to the necessity of getting things right with publicity and education on national security, and this will take sustained effort. So in principle, I support this direction. Now, my question is paragraph 15. Now, responding to comments from international labor organizations, should we simply be responding? Shouldn't we go on the offensive? Now, we are getting things right for our national security. We're standing up for our development. We're stating the fact, telling people the truth. So can we do more? Say, Can we do more in international media? Do something on YouTube? Can we tell the outside world the truth here? Now, my other question has to do with the establishment. Paragraph 20. There will be a time limited CLO, and we also have 38 non-directorate civil service posts involving up to $30 million. AI is all the rage these days. We have DeepSeek. You can gather data with AI. So will the technology help you do the work with fewer officers, or can we reduce the workload for officers with AI?
主席，
Secretary. Thank you, Chair. Thank you, Mr. Lee, for your questions and comments. In paragraph 15, we have talked about the registrar formulating responses, clarifying misunderstanding, but we won't be only practicing passive management of this. We will be proactive. We need to tell people that we have been conforming to the relevant international covenants and conventions as well as the basic law. We conform to relevant labor legislation. We are not concerned in any way that we do not conform to the relevant requirements. We will continue to do more, and I'm glad that the member thought the same. As for what paragraph 20 said about non-directorate support, we have been talking about using AI, and we do want to make use of technologies. But with the registry of trade unions, they are communicating with trade unions, and if trade unions are not making use of technologies, we need to make sure there is still proper communication. And we have large-scale unions that are doing very well in making use of technologies. But then there are many smaller unions, and we do not want to force them to transform right away because they have limited resources. While we are trying to make use of more technologies, we need to think about whether the smaller unions can catch up. We need to be prudent. Many union representatives like calling us, so we still need officers deployed to respond to their calls. We will try to make more use of technologies, but we also have to accommodate the smaller unions that do not have as much resource. Thank you. Mr. Kotwai-Kong. I speak in support of the proposed retention of the supernumerary post of Chief Labor Officer. I, however, also have some questions to facilitate public understanding of the proposal. In 2022, when the post was created, back then there were 4,000 odd applications for trade unions to be established, and the post was created for this purpose for 3 years in 2022. I think we have dealt with most of the applications. The actual increase is approximately 500. We now have 1,400 odd registered trade unions. The Chief Labor Officer will have to inspect the labor unions and regulate the conduct of the trade unions. There is a need for this post, of course. But, Chairman, you also deal with labor unions. But I would say this, once people get used to it, it's actually not that hard, this work. So if we do not see or anticipate a significant increase in the number of trade unions in future, there should be a decreasing workload. Or does the administration expect for some reason there will be an increase in the workload? And if that is not the case, I think we can just allow the post to lapse after 3 years. For the registration of trade unions, there may be a long-term need, but then we are faced with a tight fiscal position, so that we are making this post to be retained for 3 years only? Or is it the case that the government thinks that the post can lapse after 3 years, or does the government plan to retain this post 3 years afterwards? We are proposing to retain this post for 3 years because we want to get more experience, to see if there is a need to make the post permanent after 3 years, or maybe there is no such need. We do think this post will be made permanent eventually, because while the work may seem administrative, dealing with registrations, dealing with submission of documents from trade unions, but then with the legislative amendment exercise for the trade unions ordinance completed, the officers' work would also involve safeguarding national security, regulating trade unions, because in future the trade unions would have to report any dealings with external bodies, and we have some officers from these unions working overseas positions. They will need to be declared in future. So with the work of safeguarding national security, it is a continuous effort. We will not be at peace forever. We need to make sure that we have contingency plans for what may happen in future. We are estimating the workload at the moment. With the legislative amendment exercise completed, we will have a more proper assessment of what the workload will be in future to see whether we should make the post permanent. But let me say this, safeguarding national security is important and it requires continuous effort. Chair, I have some follow-up questions and comments. I hope that 3 years after that we will have proper assessments, because we don't want to retain the post for another 3 years or maybe another 3 years after that. Thank you. Mr. Kenneth Leung. Thank you. I, in principle, support the retention of this post of Chief Labor Officer. I understand that we have had many applications to deal with. There's also a need to safeguard national security. I would like to echo on the point made by Mr. Kwok Wai Keung. The question is actually answered, so I am actually quite satisfied with the answer. So I'll move on to the work of safeguarding national security. When the post was first approved in 2022, we have seen for point 3 of paragraph 5, the post would involve promoting national security education, and we have seen talks and seminars held. How many more workshops and seminars will we hold in future? In future, the Chief Labor Officer would regulate the trade unions to make sure they conform to national security requirements. There is a need for professional knowledge in national security related legislation and requirements. Apart from the Chief Labor Officer, would the 9 directorate officers prepare the relevant materials, or would we involve officers from other departments as well? Thank you. Secretary. Thank you, Mr. Leung, for your questions and comments. In paragraph 5, we have talked about the major duties of the post during the past 3 years, we have not set any targets for how many seminars and talks to be held. It's not that we don't want to make plans, but then because we would need the participation of trade unions, we need to liaise with trade unions to see how many seminars will be held. Right now, we're focusing on the quality of the seminars rather than the quantity of the seminars. On 15th of April, the National Security Education Day, we will have a specific seminar to liaise with trade unions to tell them about the legislative amendments of the trade unions ordinance, to seek their support. We will leverage on the opportunity of that particular day to do more work in this regard. In future, with the legislative amendment exercise completed, we will step up publicity and promotion. The regulation of trade unions would already be a heavy workload. In future, we need to make sure trade union officers have a heightened awareness on how to safeguard national security and what they have to do under the amended trade unions ordinance. They have more to do under the amended trade unions ordinance. They need to submit more forms. They need to make more declarations. This is a heavy workload. We'll make sure this is dealt with in future by the post. As for the preparation of materials, it would not only involve the Labor Department. We will need to involve the relevant departments to prepare materials that would not only have accurate contents. The contents should also be easily understood by trade union officers. This is what we're going to do in future. It would be me speaking now. I'm the last one to speak. With the legislative amendment exercise of the trade unions ordinance completed, there will be a heavy workload for the officer. There would have to be inspections. There would have to be enforcement. I hope that in future the Chief Labor Officer can also provide more support to trade unions. Trade unions may not be breaching the law intentionally, but because there are more requirements to conform to, there should be more support provided to them. I do have my reservations on the period of the post. As Mr. Kingsley Wong said, we have other chief labor officers in the Labor Department, for example, one working for statutory minimum wage. We now have a formula or an adjustment mechanism for statutory minimum wage. I don't think there's much dispute, and we only have a limited number of people with very low wages that would be affected. I think if there is any breach in law, we can deal with it just like we deal with any contraventions of the law. And I know that with the projections being made, it's not just the Labor Department's work. We would have the Office of the Government Economist providing relevant assessments. Can we consolidate the functions of chief labor officers and rationalize such work? I know that it may be difficult. We are now cutting 10,000 in establishment. It is already quite difficult, but I think this is the direction we should take. I hope the government will take my suggestion. For this post, on the post's cooperation with other departments, if we have completed the amendment exercise for the trade unions ordinance, we have trade unions receiving support from foreign organizations or have their officers deployed to overseas organizations. Declarations would have to be made to the registry, and I don't think you would blindly approve the applications. You would need to gather intelligence, do some research. I think you would also be providing for entry to the premises of trade unions to inspect relevant data, and I think it would have to be reasonable. And back then in 2019, I believe some trade unions had some dangerous goods kept in the premises. I think we need to have a coordination mechanism with the different departments involved in safeguarding national security. Thank you.
Thank you. So the focus is on what we do 3 years from now. As I've said a few times, the work is ongoing in nature. But we want to be prudent. We extend the post for 3 years and then we will see how things go. Our principle is to make good use of resources. I want to stress this. We have a very small number of chief labor officers. I worked at many departments. At the Labor Department, they have a very small number of CLOs. Each CLO is heavily engaged in work, but we have made this pledge. We will review this matter in 3 years' time. On collaboration, there is collaboration, but I cannot discuss that in detail here because the work is case-specific. In a very egregious case, we work deeply with law enforcement agencies. But in cases of non-compliance not involving national security, say a failure in reporting, we can handle those matters on our own. With the amended law, the Register of Trade Unions will be taking up work on national security, and the Registrar will be working more closely with departments also working on national security. That's to ensure that we deliver on the work on national security. So all members have spoken. So from what I can see, everyone supports this proposal. So after the amendment goes through, this post holder will see a change in their work, more work. And members wondered about the reviewing the necessity for the post in 3 years' time, so that's for the government to consider. So this proposal will reach the establishment subcommittee if members have no objection. The next step is to submit this proposal to the establishment subcommittee. No objection? All good. Thank you. We thank the Secretary for joining us. We now come to the next item on the agenda. Item 4. Protection for digital platform workers. We now invite the government officials to join us for this item. Joining us for this session are the Undersecretary for Labor and Welfare, Mr. Ho Kai-ming, Assistant Commissioner for Labor, Mr. Simon Lee, also Assistant Commissioner, Mr. Raymond Liang, and Senior Statistician from the Census and Statistics Department, Ms. Frida Tong. Welcome. Members who wish to speak, please press the Request to Speak button now. Now, can I first invite the Undersecretary to walk us through the paper? I believe we have slides. Over to you, Undersecretary. Before we come to the slides, I want to say a few words. Now, for our local digital platform workers, we have started our work on protecting them. So I will share some highlights. The SAR government sets great store by protecting the rights of digital platform workers. We look at the experience elsewhere. We also look at the condition of local digital platform workers. We have commissioned the CNSD to conduct a thematic household survey to collect information on the characteristics and working conditions of these workers. So the task forces gathered information. We also set up a liaison group to discuss the situation of local platform workers with major delivery platform companies and labor organizations. So we had this survey, focus groups, and also liaison group My colleagues will tell members about the details in a moment. Now, I want to tell members about our work in brief. In 2023, we set up the liaison group to step up the engagement with the other parties, meaning with workers and the platform delivery workers. In December 2024, we held a retreat. We discussed a few matters with the delivery platforms, insurance sector, and also the workers. The liaison group agreed on the direction forward, and that is improving engagement between workers and the platforms, and also enhancing protection for workers when there's an accident, better protection for workers, and on a reciprocal basis, discussion on how to take things forward and discussing feasible options for protecting platform workers based on the surveys and our focus groups. We have a few observations. One, shared concern about protection for workers when there's an accident, and this is something that platforms also agree. Legislation or not, platform workers want to keep their flexibility and work autonomy they have. Stakeholders of platforms support tripartite discussions as a way to explore feasible options and to achieve a win-win outcome for everyone. Now, based on the data and views we gathered, the Labor Department will continue to work with the stakeholders to explore feasible options to protect platform workers. The goal is to lay down the way forward within this year. I now invite Ms. Frida Tong from the CNST and also Mr. Raymond Liang from the LD to tell us about the thematic household survey, the focus groups, and the liaison group. Now, first, we will hear from the CNST. Thank you. Now, I will talk about the THS. This is a survey based on a scientific sampling of households. So we covered all non-institutional population on land. The survey was done between December 2023 and March 2024. We surveyed 10,000 households involving more than 23,000 residents aged above 15, response rate at 76%. Our target group was persons who took orders from digital platforms to deliver goods or food, and these are people aged 15 or above. So we will refer to them as delivery platform workers. Now, for the 12 months before the survey, 12,900 people engaged in such work. Most of them were males. Their education level was secondary or below. On the age breakdown, more than half of them were aged between 15 to 39, so relatively young population. Roughly a quarter were aged 40 to 49, or 50 and above. Now, about their work. For some such platform workers, they worked for more than one platform. So when we look at the 12,900 workers in the 12 months before the survey, so they were in 18,100 delivery platform workers posts, so meaning for each worker, they worked for an average of 1.4 platform companies. 73% of the 18,100 work posts, it was mostly food delivery. And then for 21% or so, it was goods delivery. On the delivery work they do, they mostly were cyclists, roughly 30%, a quarter were walkers. For the remainder, motorcyclists or van drivers, they made up roughly 20% each. Now, the work hours and income for these delivery workers. So we look at an aggregate figure. For most delivery platform workers, they could arrange their own work hours. Roughly 20% had no fixed work hours per week. 28% of them said they worked less than 25 hours a week. Another quarter of them spent 25 to 44 hours per week. Another quarter said they worked more than 44 hours per week. Roughly 2/3 of these workers said their platform work was their main source of income. Now, their income levels. As you can see from the chart, roughly a third earned an average of less than $15,000 a month. 26% earned $5,000 to less than $15,000. 37% earned at least $15,000. A further analysis shows 10% of such workers earned at least $25,000 to $29,999 per month. We also asked respondents why they undertook platform work. They could choose more than one option. And we also asked them what they valued about the work. The results showed 90% of the respondents said they liked the flexibility of platform work, ease of joining or quitting, flexible work style. The same worker could work for more than one platform at a time. These workers also had better control of work procedure, and they also had more leisure time to achieve work-life balance. Half of these workers joined the work due to financial reasons. Others liked the income level. 30% said there was no education requirements, so they decided to take up work on these platforms. Now, on what mattered the most to these workers, they liked the autonomy with work and the current pay level or income level. And they hoped they could access employee protection on a par for for employees. So these are the highlights of our results. Now, some limitations for our survey. Platform work made up a small fraction of the overall employment in Hong Kong. So we only surveyed a very small sample. There may be greater random variation, so we could not do any comprehensive or detailed analysis. So we can only provide limited breakdown. We only covered 12 months for the survey, and these questions involved things that happened further back in the past. For platform workers who took an order every now and then, they struggled to recall the details, so there may be larger sampling errors, and that's something you want to bear in mind when reading the data. Now, I will give the floor to my colleague from the Labor Department to tell us more about the opinion surveys and the focus groups. So can you be brief, Assistant Commissioner? Thank you. Ms. Tong mentioned a survey designed scientifically, and for my part, I want to tell members about the opinion surveys and focus groups done by the LD. So we asked delivery workers. It was done in July 2024. We got roughly 2,000 valid responses. We held 8 focus group meetings, face-to-face meetings. 51 delivery platform workers took part. There were 3 factors they felt warranted most urgent attention. 1, illegal workers. 2, income stability. And 3, work-related accidents and compensation. We asked these workers whether they support legislation to enhance protection for delivery workers. A majority, in fact, many such workers, 36% or so, supported enhancing protection through non-legislative means. There were also more than 30% of the respondents who backed legislation, and then for the rest, they either had no comment or were happy with the status quo. On what kind of benefits these workers wanted. They wanted compensation for work-related injuries, 39%.
At the focus group meetings, the views were roughly similar than those I talked about earlier. Participants in the focus group meetings were also concerned about the retirement protection for platform workers, inadequate support for work safety, as well as the relative lack of transparency of the mechanism for allocating orders, setting delivery time standard, and giving rewards and imposing penalties. That's it from me. Thank you. Thank you, Assistant Commissioner. I'll assign a 4-minute time limit. I'll read out the order in which members are going to speak. Mr. Luk Chung Hung, Professor Chan Wing Kwong, Dr. An Men Yu, Mr. Chao Siu Chung, Mr. Kingsley, Mr. Lee Chen Kung, Mr. Kenneth Leung, Mr. Kwok Wai Kung, and myself. I will first ask Mr. Luk Chung Hung to speak. Thank you. Chairman, I'm not sure if you felt the same way. This is an anticlimax. The paper we have heard grand gestures, but there's no concrete action. We have been promoting protection for digital platform workers for long. We have been calling for better protection since the last term of the council. We have finally passed a bill. In fact, in the third plenary session of the 20th CPC Central Committee, we have talked about providing better protection for this new type of workers. So on a national level, we have already been doing something. I'm not satisfied with the paper they submitted today. They are just talking about facts. General facts. They have done some studies, they have consolidated the information, and they have basically conveyed information that have been cause of the labor sector. They don't even have a way forward. They don't have any plans. I'm very disappointed. I think the figures are very rough too. If it was an academic paper, I wouldn't give it an A. The income distribution is quite rough. One of them is from 5,000 to 14,999. There's no median income. There is no comparison year on year of income. There is no further breakdown of the income figure. These are key data for delivery platform workers. You spend much effort and resources to conduct a survey. Is this just to say that you have done some work? I think there should be a higher level leadership when conducting such surveys to make sure we actually have a way forward. I'm not sure what the administration is trying to do. In the mainland, they are trying to regulate the enterprises, the platforms, so as to provide protection to platform workers. The UK would adopt a worker model. There's also legislation in Singapore. What are we waiting for to do anything? Last year, we heard that there would be a study. I was hoping for some way forward. We have seen the findings. Basically, they're saying they would conduct further studies. When will they stop conducting studies? Chair. I think I have doubts as to whether the LWB has any plans to complete the relevant work within this term. I am confident that the chief executive will be elected for a second term, but then I think we should not wait until the end of this term to have a framework for protecting digital platform workers. Right now, we only have 2 major platforms. We used to have 3, but one has closed. I think it's very easy, and honestly, when a platform closes, there will be disputes. When there are accidents, the workers are not protected. I think as long as you have determination, you can do something. Perhaps you should leave some time for the Undersecretary to respond to your questions and comments. Undersecretary, thank you. We talked about within this year we would formulate a way forward. Thank you, Professor Chen Wen-kong. On this item, I have some follow-up questions. We have seen digital platforms being developed rapidly in many different places. In the mainland Singapore and other jurisdictions, we have seen legislation being promulgated to provide protection to the platform workers. We're still at the stage of conducting studies and gathering views. We can only map out the way forward at the end of this year. I think we are lagging behind. Not only can we not guarantee the interests of platform workers, it is not conducive to the development of gig economy in Hong Kong. How can we have a regime that would actually protect platform workers? What is the timeline for promulgating such a regime? With inadequate protection for platform workers, I think the cause is that there is no employment contract signed between workers and platforms. So there is confusion as to whether the workers are employees or self-employed persons. In turn, that would affect what labor rights they're entitled to, such as MPF. Can we refer to other jurisdictions' experience, such as that of Singapore, to give independent status to platform workers somewhere in between self-employed persons and employees? That is a third category of workers, so that they can sign specific agreements in this regard, and that would deal with any disputes or accident protection. I think the foundations are we need to provide better protection for digital platform workers, but then there's also some confusion and some breaking the law. We have had illegal workers. We have also some workers that would neglect road safety. They would cycle on the roads. Sometimes they would cycle on pavements without regard to the traffic rules. They also park illegally. It has caused much nuisance to the general public. On protecting digital platform workers, while we think about that, we need to make sure the workers will not cause nuisance, to make sure the sector is developing healthily. Thank you. Apart from what Professor Chen Wen-kong asked, we had Mr. Lu Chung-hung talk about the findings, whether there can be further breakdowns and more detailed figures. Let's ask the Undersecretary to supplement these answers as well. If we have the time, we will make sure to answer the other questions as well. As Professor Chen Wen-kong said, in other jurisdictions, they have different practices. We will determine the way forward within this year with reference to the experience of other jurisdictions. In the opinion survey, we have actually observed that workers want to have some flexibility, which is why the arrangements are fake at the moment. Because workers want free entry and being able to leave without much restriction from the sector. We want to make sure we can strike a balance to meet the workers' needs as well as provide better protection to them. As for cyclists, I think whether they're employees or not, they are drivers, so to speak, as cyclists. They need to conform to the relevant rules. They need to conform to the laws of Hong Kong. We will work with different departments to take enforcement action if necessary. I think Professor Chen Wing-Kong asked about when there will be a regulatory regime. We do not have a timeline at the moment. We will determine a way forward within this year. As for what Mr. Lu Chonghong asked about the specific figures that we can provide, is it the CNSD or the Labor Department officers will answer this question? Ms. Frida Tong, sorry, due to a limited number of samples, we cannot provide the breakdowns. As for year-on-year comparisons, because it has been some time ago for platform workers, it's hard for them to remember. I think due to potential inaccuracy, it's not appropriate for us to include such figures in our findings. Thank you, Dr. Aman Yu. Right now, we are talking about figures. And in fact, we only have figures to talk about today. I think the findings do not touch on the specific issues, whether the workers have signed agreements with the platforms, whether they have any work-related injuries, whether they have insurance taken out, whether they are paying taxes. I think we need to ask why the findings do not touch on these issues. Why didn't the government ask these questions? For the focus group meetings, why didn't the platforms participate in the focus group meetings? Can't we have them take part in the focus group meetings to have these platform representatives talk about insurance or work injury protection? Why didn't we involve them in the meetings? Thank you. I will ask Mr. Raymond Liang to answer the questions. Thank you, Assistant Commissioner, Mr. Liang. Thank you. Let me talk about what happened in the focus group meetings. We actually want to get a better understanding from the platform workers on what was happening. As for whether we have liaised with the platforms directly to have a better understanding of their conditions and arrangements, we have a liaison group that was set up in 2023. In November of last year, the department organized a retreat in relation to platform workers. We had involved the platforms. We have also involved other professionals, such as the academics and a representative of the insurance industry, to jointly look into the topic on protection for platform workers. Of course, we also involved some platform workers for the retreat. As for what Dr. An asked about, why we didn't involve the enterprises in the survey, it is because for this survey, we wanted to gauge the income situation of the workers and the workers' understanding of the model of work. I don't think it really matters as to whether there is an employment relationship, because most workers regard themselves as self-employed. I would say this, however, for the platform workers, whether they are employees, whether there is an employment relationship, more often than not, we have to have regard to a number of factors to make a determination. For a worker who is engaged with a platform for another worker that is also engaged with the platform, maybe due to differences of their use of service, maybe due to their different contracting agreements. They may not have signed an employment contract, but they may have signed a service agreement that may have different conditions. Sorry, Chair, I only have limited time left. I want to ask some follow-up questions. We're talking about providing protection for digital platform workers. We have the different liaison group, focus group meetings. Why didn't they spell out the liaison group meetings findings? Can't they talk about what the platforms think? Of course, I understand that there are differences with each worker, which is why we are conducting a survey. If they offer the same level of protection, we wouldn't need a survey in the first place, Assistant Commissioner.
Now, in the paper, we briefly brought up the views that came up during the retreat. That's in the paper. Paragraph 8 and paragraph 9. Those two paragraphs cover the work done at the retreat, and we will continue to work along that direction. Next, Mr. Chao Xiu-chung. We're discussing ways to better protect platform workers. We have been discussing that for years. Our country launched many policies to protect such workers. Overseas, different places also made progress. Singapore enacted legislation for that. Over here, we have been making no progress. The government has been telling me since 2021 about a comprehensive survey involving the C and SD, and then with the survey, there will be a way forward. Now, this survey has come out. So you started working on the survey in 2021. You spent 2 years on discussion, and then another year went into the survey. Now it's been 4 years. The results are disappointing. We want to protect platform workers. For that, the way forward should first involve whether this worker is a self-employed person or bogus self-employment. But our survey does nothing to help us clarify the status of these workers. The survey isn't doing anything. The officials know this. To determine whether there is employment, we don't just ask whether the worker is free to take up the work or not. 98% of the respondents said they were free to take up the work. Can you rule out employment simply based on this? No. So many factors are at play. Did you ask those workers whether they had to put on a uniform? Were workers really free to take or reject orders? Were there consequences for not taking orders? Were there penalties from the algorithm? None of these was asked during the survey. So this survey is doing nothing to help us. Now, work-related accidents. Why did the THS leave out work-related accidents? How many workers were injured during work? The compensation varied from one company to another. What was the situation like? This was left out. So this survey isn't meaningful. And even the Census and Statistics Department told us they had a very small sample. You spent years on the survey. If you had a problem with the sample size, find a larger sample. You said the sample size is too small for a meaningful, comprehensive analysis. So this survey is not providing us with the basis on which we discuss protection for platform workers. Now I come to my questions. So 23,000 people, how many of them were platform workers? And can the CNST elaborate on what they mean by a small sample? Now, Ms. Frida Tong can tell us about the survey in a moment. I want to say a few words. We have covered certain things in the survey, say things workers felt warranted attention. Many felt illegal workers were a problem, and then income stability, another point of concern. 37.9% for work-related accidents. We have stated those concerns from the platform workers. In some cases, we had too small a sample for analysis. Now, Ms. Tong can tell us more about that. We surveyed 23,000 people, but how many of them were actually in this industry? Now, for food or goods delivery workers, they were grouped under local postal or courier services. Now, we can give you a rough estimate of people actually in this industry. Every year, the CNSD conducts an integrated thematic household survey, and the people in courier and postal services number roughly 23,000 people per year. That's after the COVID. Before COVID, it was 19,000 people. That's because this industry saw rapid growth during the COVID years. So there was an increase of 20% from 19,000 to 23,000 workers. Not everyone worked on a platform because there were also people working for postal services or courier services for SF Express or DHL. They were also grouped under this category. So we have 3 million working people, and this 23,000 people made up less than 1% of the 3 million workforce. So for this sample size, it's less than 1% of our workforce. Because of this small size, there was little we could do. Now, on whether we could do a larger sample size, that's one way forward. It takes time to find a sample. We surveyed 10,000 households. That took us 1 year on designing the survey, gathering the data, and collating the data. Working on a larger sample will require more resources and much longer time, so that would cause problems in terms of resources. Now, on work-related accidents and compensation, we had that in mind when we designed the questionnaire. But finding a sample involving work-related accidents is even harder because not every worker got hurt. So that would point to a much smaller sample size. Even when you have a sample of tens of thousands of households, you cannot find a large enough sample for work-related accidents. We also did the opinion surveys and focus groups. That represented a more targeted approach because those reach out to platform workers through the platforms. So in the future, we can try to reach out to platform workers and put questions on those points that will work better. Next, Mr. Kingsley Wong. This topic is nothing new. I think this survey is actually misleading. Now, on work autonomy, these are low-level work. People can join or leave the work easily. There is no real freedom. The work autonomy is simply an excuse to not provide protection. 10% of these workers made more than $25,000 a month, but we have left out the work hours. I know many people work more than 10 hours a day, and that's how they earned $25,000 a month, and that's not reflected. Now, closer to my heart is another issue. There are two kinds of workers. One, van drivers, they may own their vehicles, But then for delivery platforms, food delivery workers, those are more grassroots workers. So we have to find ways to better protect these platform workers. And one point raised by other members is how we determined the employment relationship. We had the Z case. In some court rulings, employment relationship was established, but that's not the case with other rulings. One platform just pulled out of Hong Kong. When workers first joined, they had a base salary, and then they were paid on the piece rate. Some workers worked for many years, and when this platform pulled out of Hong Kong, how could these workers recover compensation? Here, the employment relationship or the absence thereof makes a difference in the success of recovering the payment. Many of these workers were freelancers, but they were not professionals. Shouldn't we make it a priority to protect these workers? The Supreme People's Court issued guidance along with the court ruling. The stress was on how the worker was deployed, whether there are requirements from the algorithm, whether there are reward and penalty systems. Workers signed an agreement with the platform as self-employed people, but the actual labor arrangements made it clear that those people were actually employees. I know there are two platforms in Hong Kong, one from Germany, the other from the mainland. Those platforms approach protection as a matter of employment. So my question is, it's clear the mainland already has a definitive court ruling, and there are more than 11 million delivery workers in the mainland. Once you establish an employment relationship, can we look at the framework already in place in the mainland and in Germany? Undersecretary, on work hours, we have covered that. So you get roughly equal numbers of people working for less than 25 hours, 25 to 44 hours, or more than 44 hours. On the court ruling in the mainland, the principles are similar to those adopted by the Labor Tribunal and the courts of Hong Kong. In determining whether there is a employment relationship, we look at the control over the worker, the provision of equipment. I think Mr. Kingsley Wong is well versed in that. The principles are the same. You get different court rulings because of the different facts of each case. Now, in a B2B case, the court found in favor of the worker, but in another case, the court found against the worker for the food delivery platform. The principles are the same, but the outcomes will hinge on the facts of each case. So we will set out the way forward this year, and we will follow up accordingly. Mr. Kingsley Wong, please be brief. A follow-up question. Because court rulings can go either way, can we clarify that? Let's look at the mainland. They offer guidance. Delivery workers get a clear legal status. Can we do that in Hong Kong? Undersecretary, we will set out the way forward. We will present that to LegCo this year. Mr. Michael Lee. Digital platform workers are exposed to elements in their course of work. They deserve our respect. We talk to them. We ask them whether they want protection, through legislation. Some live in public rental flats. Some work as platform workers on a part-time basis. They don't want the other employer to know their work. Others have tax concerns. So do we really need legislation as a prerequisite for work-related compensation for work-related accidents? So let's look at something closest to their hearts. 1. Illegal workers. That's a matter of concern not just to delivery workers. That's also top of mind for the Labor Department. So this hinges on due diligence by the platforms. A delivery platform worker logs onto a system. Is their fingerprint, is their facial recognition? With that control in place, you can prevent account sharing or someone accessing those accounts without authorization. Banks already have such safeguards in place. Technology can guard against illegal workers. And when you get subcontracting of work, a worker takes an order. You should be able to tell something is wrong given this gap in the time. And now on income stability, work pays, you earn more by working harder. On holidays or during typhoons, workers should get paid more. Now, on compensation for work-related accidents, this is a separate matter from an employment contract. So can we have some kind of bulk insurance policy to be taken out by the platform? And all that means costs, and the costs will be passed on to consumers. When contracts and compensation are required in the future, that will also mean extra cost for consumers, and we should be cautious about that. Thank you.
Thank you. Undersecretary, I'll let Mr. Raymond Liang answer the questions. Thank you. The government is committed to combating illegal workers working in Hong Kong. We have worked with the Immigration Department to take enforcement action. We have in operations arrested some illegal workers, whether they're working for the delivery platforms or not. Whether we can request platforms to do more to make sure we can prevent the problem at source by, say, identity verification. We will convey the relevant ideas to the enterprises at the liaison group meetings. For example, the issue that you mentioned, having sub-workers, I think we need to think about whether that is allowed in the first place, and we will discuss this with the platforms at the liaison group meetings. Thank you. Mr. Kenneth Lang, from the figures, we have seen over half of the respondents are age 15 to 39. And the average age is 38.4 years old. We have seen a lot of platform workers having this as a major source of income. That probably reflects a trend. We have often talked about there being a manpower shortage for different industries. Have you surveyed the qualifications of these respondents? I also want to know, you said the majority would be males, over 80%, many of them in the younger age group. Is there any way for us to unleash the potential of, say, females working for these platforms? Next, During the PowerPoint presentation in slide 12, we have talked about why the platform workers work these jobs. Many of them like it being flexible, and they also want to have better control of work procedure and style. What exactly are the differences between the different reasons? Ms. Frida Tong. On academic qualifications of respondents, most of them have only attained secondary education level. It is in general lower than office workers, for example. As for the reasons, many are quoting income because they want a higher income to meet their family commitments. So they think they can earn a comparable income while working the same hours as different when compared to different jobs. So they chose to work for platforms. Any follow-up questions? None. Thank you, Mr. Kotwai Kang. I think the chairman would understand, and in fact, I think the officials would understand as well. Most members are quite disappointed with the paper provided by the administration. There is no way forward. We may not have specific policies, but I think there is incompleteness with the information collected. I think that is a general consensus among members. We have talked about providing protection for digital platform workers for several years, and there has been constant delay in providing protection for them. We have been moving forward in terms of the economy, but we haven't really moved forward much with protection of labor. We often have to refer to the practices of other jurisdictions instead of being pioneers ourselves. The administration said the views collected, said the workers like the flexibility and they need the flexibility. I think this is an egg and chicken problem. If a job provides income for one to meet their family commitments, I think in general people would understand that there is not as much freedom involved. But right now workers can't work for a single platform to have the income they need. They need to work for multiple platforms. I don't think they enjoy this flexibility. Really, they just want to have a better income. I have actually gauged the views of workers. Many of them work for at least 10 hours per day, especially for drivers, because they have other expenses related to the car. And we have some working for over 14 to 15 hours. You didn't even provide any of such figures. Do you have a good understanding of what workers actually face? I think with legislation, I don't think you can get up to speed right away, but can you start with something in the next 1 or 2 years? It says that 62% of the workers think illegal workers are a priority issue. Having identified it as a priority issue, what would you do exactly? Will you take more enforcement action? I don't think you have done any follow-up in terms of these issues identified. We have 39% of the respondents who are concerned about work injury protection, and you don't even have a way forward for that. We only have 2 major platforms, We have a number of small and medium-sized enterprises, but we only have 2 platforms. Why not liaise with them to provide protection to workers in this area? I think we have to regulate the platforms, their algorithms, and we dealt with Seek before, as well as Deliveroo. Mr. Ko Kung, I think you need to leave some time for the Undersecretary to respond. I'm only several seconds away from the time limit. Why not let me finish? If the platforms are potentially going to default in payment, why not put funds in a fund so that if anything happens, payments can be made out of fund to workers? Thank you. Undersecretary. We only have a quarter of the respondents saying that they want to work stable hours. We know that 3/4 of them actually work very short hours. They may have other jobs or they have other commitments, say family commitments, so they just want to supplement their income with this platform work. I think we need to conduct further studies to determine the way forward. All right, on work-related injuries and illegal workers, any supplementary information to be provided. We have been working with the Immigration Department to conduct inspections. We had two specific operations to deal with illegal workers. We have inspected different types of premises. We do not only target platform workers. In 2024, we have undertaken 13,306 operations. We have arrested 400 odd illegal workers who are non-ethnic Chinese. Thank you. Mr. Xu Kafei, we have been talking about developing new quality productive forces with regard to local circumstances, and digital platforms are a part of this. They would make use of technologies to advance development of the economy. They would help other enterprises that need goods to be delivered. They would also benefit workers who are delivery workers. They would also benefit consumers. It is a win-win situation for all with the development of these platforms. I think we are most concerned about insurance not covering these workers, as these workers are not employees. When there are accidents, what will happen to them? I have actually received letters from platforms in the past 2 years. They said they did take out insurance to protect workers. I think you should try to verify their claims. Whether we should have more in legislation, I think it is arguable. From what I know in other places, when they have put in place more laws, the income of workers actually decrease after that. It is because with higher costs have been passed on to consumers. The consumers saw the prices being higher. They would have less incentives to order, resulting in less orders for platforms. It has actually hurt the delivery platforms in the end. It does not help with economic development in the end. As for protection for workers, we need to really understand whether workers choose to work for such platforms or that they have no other choice but to work for these platforms. I think right now workers have many different options with work, and 75% of them are actually working part-time according to the findings. It is probably because they have other jobs or they just prefer working shorter hours. I think many quoted flexibility as a reason why they want to work for such platforms. As for workers who chose to work for more than one platform, it is their choice. Hong Kong has always been advocating for earning a higher income while working because they're working more, and I think that is a good value. With workers working more to ensure operations of society run smoothly, I think that's worth respect. I think we need to gauge the views of the workers to make sure that this is what they want. However, and I think as Mr. Kwok Wai Keung said, we need to make sure there aren't any sub-workers. We need to make sure there is identity verification, because restaurants and consumers won't be verifying their identities. There is a loophole that may be exploited. We need to prevent illegal workers from being engaged at different stages of the process. It is a free economy. I think we need to allow some flexibility. Well, I do not require any answers. Well, is there any response to be made by the Undersecretary? Please be brief.
We know some platforms do take out insurance. Employees tend to get better protection, so some people feel that platform workers don't get enough protection. We will put out a proposal within this year. Now it's my turn. Some members are let down by the THS because the survey comes without specific policy recommendations. A trade union would have been able to compile a similar study. We would have got a smaller sample size, but the outcome would have been the same. Workers not happy about compensation for work-related accidents or income stability. There are two options ahead of us, a legislative or non-legislative option. The legislative option will be more complex. The government will need time to look into how it will work. One possibility is to create a different status for these workers, and that involves the law. It's complex. More time is needed to study the matter. I get it. As for the non-legislative option, can we take certain immediate action? Can we think about what we can do here? Some respondents felt that there wasn't enough protection for work-related accidents. Some platforms took out insurance for accidents, but some workers felt that didn't go far enough. So, can the government do more to encourage platforms to take out insurance policies offering stronger protection? Can we talk to platforms about that? If the premium is too high, there's a joint insurance scheme at the LD. Can the LD talk to insurers for more concessionary rates for premiums and meet each other halfway? Platform workers who reject orders may get penalized, and those penalties may not be disproportionate. The penalties may be harsh, affecting those workers' income. And the platforms get to change the terms. Workers who are not happy are simply asked to go away. They can work for a different platform. So we need a more symmetric relationship. When platforms revise their rules, can those platforms first consult the workers? I know there's this liaison group. Can we turn this liaison group into a tripartite group involving the Labor Department, the platforms, and also those delivery workers? with such a tripartite platform, the platforms should first consult the workers before changing the rules, and then the Labor Department can coordinate the discussion. Can we put in place such a standing mechanism? This option involves no legislation. Can we put that in place sooner? Undersecretary. On the liaison group, the Assistant Commissioner can tell us more in a moment. Now, on the joint insurance scheme, that scheme is for work where people cannot take out insurance, such as scaffolding workers. That's not to say that option will lead to lower premiums. To get a lower premium, we will have to work with the insurers and the industries involved for risky tasks, and that may include delivery work for platforms. The premium will be different depending on the tasks involved, say whether driving is involved. Now, Mr. Raymond Liang can tell us more about the other points. Chairman, you mentioned the non-legislative option as a way to better protect platform workers. We support this. We've been working along this direction. On insurance, now improvements have been made over time. Of course, the closer the protection for delivery workers get to employee-level protection, the better. On compensation, we have been strengthening this as well. At first, we got the platforms involved, and then we got workers' groups involved. We will continue to review how things go in the future. 2 members would like to speak for the second round. We still have time left. Let's do 2-minute rounds. Let's keep it brief. Mr. Charles Yu Chong. Thank you, Chairman. We're talking about the way forward, about protecting digital platform workers. We care deeply about the survey because we want a clearer picture over whether these workers are employees. If they are, we will have to make it clear. We will have to crack down on bogus self-employment. But if, through a scientifically designed survey, we find that these workers are unlikely to be employees, then shouldn't we be adopting the practice from elsewhere, meaning we create a third class of status for these workers? Now, my questions. The survey says there were 12,900 such workers. How credible is this figure? I looked at LegCo's research. 5 platforms, 110,000 workers. That's electrical research. How should we make sense of these different figures? And then the LD commissioned a study. 1,980 responses. How did we find these workers? Did we put out an online questionnaire, or did we reach out to them through the digital platforms? Is that figure credible? Thank you. Undersecretary. The CNSD, Ms. Tong, can take the questions. On the number, 12,900 persons. We have a figure, 15.4%, and that's a high level. We surveyed 10,000 households. We got a small number of delivery workers, so that leaves greater room for statistical variation. On whether we can ascertain the status of a worker during the survey, we thought about that before the survey. To determine whether someone is an employee, that will involve work, deliberations, through a court process. More than 10 factors are involved, so we cannot determine whether someone is an employee through just a survey. To avoid a misleading outcome, we left out that factor. Mr. Chow also asked about the opinion surveys and focus groups. How we approached the 2,000 workers. We worked through the liaison group. There were 5 platforms. We forwarded links to the platform workers through those platforms. Interested workers could respond not to those platforms, but to a body we commissioned, and then the data analysis proceeded from there. Mr. Lok Chung-hong. We're in trade unions. Trade unions also have a role in educating workers. What matters the most for workers is the income level. But workers may overlook certain risks, say no insurance coverage for accidents or a compensation level way below that under the ECO. Workers also may be oblivious to the fact that they are under the control of algorithms. I wonder whether the autonomy is real autonomy. So I wonder if the government can share details on what I'm going to ask about. You don't have to ask many workers. 1. We got only 2 platforms left. Is the insurance offered by those 2 platforms on a par with that under the ECO? If not, do we have a sense of the difference? And 2, control under the algorithm. The survey asked about a reward and penalty system. Most respondents said yes. We checked with workers. Workers told us they were forced to jump red lights, they were forced to engage in speeding, and that means safety hazards. So have we found out about the details of the systems? Are there hard limits on delivery time or the number of orders workers are expected to take? You don't have to ask many workers. It's a qualitative assessment. You can send someone on this undercover operation. We just need more details. Undersecretary, a brief response would do. Mr. Lok asked about the penalty and reward system. A reward and punishment mechanism is in place at every workplace. But whether someone is an employee or not, they have to follow the traffic rules. Breaking the law poses a danger, not just to the worker, but also to other road users. So we call on all delivery workers to follow the traffic rules and legislation in their work. Mr. Lok and other members asked about the insurance coverage offered by the platforms for the workers. Please provide a written reply if that's possible. So all members have spoken. We thank the government officials for joining us. Based on members' views, please let us know the way forward. Thank you. Next item on the agenda, any other business? There being no other business, I adjourn the meeting here. Thank you.